you for getting out of bed early and taking the trouble to be here. Our topic this morning, as you know, is reforms to the civil procedure regime. I think there are bills in the federal parliament and the state parliament for new civil procedure rules. Our speakers are David Bailey and Kate Burke. David's going to speak first and give an overview of the changes, and then Kate will speak after the break. Kate will speak covering the effects and the consequences of the changes. A little bit of intro for David. David's been in practice a long time, despite his youthful appearance. He was a partner at Freehills before coming here, and he's been at the bar now about 10 years. Cheap jokes, of course, I shouldn't make. For the purposes of this morning, one of the qualifications of David I should mention is he is currently the senior editor of Williams Supreme Court Practice, and therefore David has a daily involvement with procedure and the changes being made to the procedure regime, and therefore there couldn't be a more qualified or better person to explain the changes to us. So we'll start this morning with David Bailey.
Good morning, everybody. Thanks, Michael. That introduction. Yes, in terms of practice and time one's been in it, one of the quotations at the start of the paper is about the rules brought in just after the fusion of law and equity with the new Judiciary Act regime, and someone said to me, "Well, I know why you put that quote there, David. It was just when you came into practice." This paper falls into two halves roughly. I'll be dealing with the overall view of the changes, and Kate will obviously brought a mind to bear on what the possible consequences are for practitioners, and I think you'll find there's some encouragement there. It's not all bad news, but as we've found over recent years, the pace of reform these days has stepped up a lot, and it's now working its way through the civil justice system. The two, one is a bill and the other one is now an act. The Civil Procedure Bill of 2010, introduced into the Victorian Parliament, I gather from Kate, was passed a few days ago, so we're now dealing with reality rather than possibility. The Civil Dispute Resolution Bill in the Commonwealth Parliament reached second reading stage, and then we had a few events in Canberra which may have delayed the process a bit, but one has to assume that it will eventually be passed one way or another, because it's part of a suite of reforms going on in the federal area. Now, what both bills seek to do is to bring about cultural change in the conduct of litigation. I suppose instead of perhaps using the word litigation, one might say dispute resolution, because what they're trying to do is to see dispute resolution as a holistic process whereby some control must be exercised prior to any issue of proceedings to see that the best outcome for not just the clients and the parties and their lawyers is concerned, but also for the administration of justice and the use of the resources of the civil justice system. So I've begun by trying to set some scene for this. I note that in England a couple of decades ago we had the Wolf reforms, which in some ways have some similarity to what's happening here. That is that the fundamental change that Lord Wolfe sought to bring about was to bring in his terms, an overriding purpose which would govern all aspects of the conduct of civil litigation. And so what we find here in both the Australian, or the Victorian and the Commonwealth proposals is an overarching purpose. In the Commonwealth, it came in via the Federal Court of Australia Act last year, but you would take it together with the current bill and you get the same holistic approach of an overarching purpose, then followed by some rules changes. So why do you have an overarching purpose? We say that the common aim of both reforms is to encourage steps to resolve disputes from a broader perspective, that is, with a view to limiting those proceedings to ones which really need to run, as opposed to those that might be disposed of before even issuing proceedings. Now, just comparing the two very briefly, the Victorian reform covers not just the overarching purpose and the pre-action steps, but it also covers some discovery reform and disposition before trial by reforming the summary proceedings test or summary judgment test. We don't propose to deal with discovery or summary judgment today, so we'll just be concentrating on the overarching purpose and the pre-action steps. Now, just to be different, the Commonwealth has called, well, the procedure there is that prior to issuing civil proceedings in an eligible court, an applicant must file a genuine step statement. And a genuine step statement is a statement filed by an applicant or by a respondent under clauses 6 and 7 of the bill. And what's that statement all about? Well, it must explain the reasons why no steps were taken, if they aren't taken, or if they were taken, what they were. There are some, apart from the exceptions, which I'll refer to in a moment, obviously there are cases where you might need injunctive relief or some other urgency so that you would not go through a genuine steps process, but you would simply say to the court when you do get round to filing the genuine steps statement that for reasons of urgency, genuine steps were not undertaken. But they would have to be substantial. There'd have to be a reason for them. It couldn't just be expediency. As I say, it would need either, in fact, they talk in the explanatory memorandum of the urgency, safety or security of a personal property as justifying not going through a genuine steps procedure. And finally, the procedure must comply with rules of court. So in the case of both reforms, I think we're going to see pretty substantial changes to the rules of court. Of course, until one sees those, it'll be impossible to get a complete appreciation of where we're headed with this, but Kate will make some observations about what this might mean for procedures and the rules, and I've picked up a couple of things on the way through which I'll mention. The Commonwealth reform implements recommendations made by the National Alternative Dispute Resolution Advisory Council, or NADRAC, which were made in 2009. The other thing about this new process of having an overarching purpose combined with pre-action steps is that the obligation is not just imposed on the lawyers, but it's also going to be imposed on the parties themselves, so that the court is trying to control the whole process by being able to deal with everybody before it. And we'll see how this works through when we get into the detail of the proposals. Now, I mentioned a moment ago that a respondent also has an obligation to file a genuine step statement, particularly where the respondent disagrees with the applicant's genuine step statement in whole or in part. The respondent should respond by specifying the respects in which and reasons why the respondent disagrees. The lawyer is under an obligation in filing the statement to advise the party of the requirement and to assist the party with the requirement. So you'll have a positive obligation to take your client through the need to go through this process. So the client might come in saying, well, I want to sue X, can you issue proceedings tomorrow? You'll have to say, well, just hang on a moment. There's a process we have to go through, which is, have you tried to resolve the dispute beforehand? If not, why not? So on and so forth, and explain what's required. Well, what happens if you don't do that? There's a cost penalty, and the cost may be awarded against a lawyer. Well, we're familiar with that requirement already in other contexts, but the cost penalty is going to be used as very much the way that these reforms will be introduced. Now, the Commonwealth Bill then goes through what are genuine steps. It's not prescriptive, so it doesn't say if you've got this sort of dispute, you've got to have a mediation or you've got to have an early neutral evaluation. It simply says that examples of genuine steps are various things. For example, notifying the other side there's a dispute, offering to discuss the dispute with a view to its resolution, providing information to the other side to say, well, I believe that you have an obligation to me because of the following documents. What are you going to do about it? Processes which I think we've all gone through anyway over the years in an informal sense anyway. And also, of course, agreeing to a more formal process such as mediation or early neutral evaluation or perhaps expert assessment. So, as I say, it's not prescriptive, but it needs to be geared to the circumstances, and this is taken a bit further in the Victorian Act, as we'll see shortly. Now, and I make the comment in the paper that it would be an unusual case where most lawyers have not already tried to bring about resolution of a dispute with some form of steps before they issue, so that this doesn't come as a great surprise to most of us. What does, I think, come as a bit of a surprise is that it's now going to be formalised as part of our process, and that the consequences of not complying might become quite significant for us and our clients. Then the bill deals with the consequences of the procedure, and as I mentioned a moment ago, the main weapon of the court seems to be in the costs allocation. However, what the court does is to look at the genuine steps that have been taken. So it looks at the genuine steps statement and says, well, what have the parties done to try and resolve the dispute? What might be the best way to manage this dispute as it now proceeds through the court process? And so the court might take the view that an early mediation would be a way of handling it, or perhaps limiting the timetable in some way, making orders about pleadings or evidence and so forth. Now, there's a whole list of excluded proceedings, so the genuine steps procedure doesn't apply to, for example, proceedings for contravention of a civil penalty under, for example, the Trade Practices Act by the ACCC, or under the Corporations Act by ASIC. And so there's a laundry list of those which I've set out on page 6. Proceedings under various Commonwealth Acts, matters excluded by regulation. So they'll become well known. And now the other question is which courts does it apply to? At the moment, it's proposed for the Federal Court and the Federal Magistrates Court. I imagine the reason that family law is not involved is that that jurisdiction already has fairly comprehensive procedures for mediation and dispute resolution outside the strict court system. Well, now turning to the Victorian Act, what one finds is perhaps a more comprehensive treatment than the Commonwealth Act or the Commonwealth Bill. The Commonwealth Bill is quite short, but the Victorian one, I think because of the fact that it's got a number of measures apart from the overarching purpose and the pre-action procedures, condescends to a bit more detail, and one also sees that it contemplates changes to the rules, and we've tried in the paper to indicate what rules changes might be involved, and I'll go to a couple of those in a moment. But starting off with the so-called overarching purpose, one takes the pithy statement that it is to facilitate the just, efficient, timely and cost-effective resolution of the real issues in dispute. Now, that seems simple enough, except when you go to dig down into what it means, you'll find that it then gets expanded out into a number of limbs which might make for some complexity, I suppose, when the court comes to apply the overarching purpose. Now, we already have, those of you who are familiar with the commercial court will know that in the practice note there are set out objectives for proceedings in the commercial court. They're very similar to the overarching purpose in a number of ways, so a lot of this won't come as a surprise, but what I think might be difficult is to assume that in every case, every sort of proceeding, that the overarching purpose and the objectives will be identical in each case. It's going to be, I think, necessary for particular lists to develop or hone up a set of obligations more attuned to that list. So you'll see that the overarching purpose will be a common objective, but for a particular list I believe that you'll need to have specific protocols, and Kate I think will talk about that. Now, as I said before in relation to the Commonwealth Bill, the overarching objective is mandated not just for the lawyers, but it now applies under the Victorian Act to any person who's a party, any person who provides financial assistance to a party, such as a litigation funder, any person who's an expert witness. And they will have to be aware of their obligations to the court, which obviously will sound in obligations as well as costs, and the ability for the court to deal with people who don't comply with the overarching obligations, which give effect to the overarching purpose in some way. I've set out on page 8 of the paper what they're called overarching obligations. So you have an overarching purpose, overarching objectives, and then overarching obligations. This is a laundry list of things that the litigants are supposed to do. Paragraph A is to act honestly at all times in relation to civil proceedings. Not quite sure where that could take us to, but it's obviously a very broad prescription and certainly going to impose a problem for some litigants I know. Anyway, not to make a claim or response that's frivolous, vexatious and abusive process, etc. Well, again, that doesn't come as a surprise. It's already, of course, something which is provided for by the way the rules currently are applied, for example, under Order 23. Not take any step in a proceeding unless the person reasonably believes it's necessary to facilitate the resolution or determination of the proceeding. One concept which one finds flowing through all of this is the concept of proportionality, so that the steps or measures taken must be proportionate. And it's a word which one comes across in the English context of the Wolf reforms, and I think we'll see it here. Well, I won't go through all of these except to mention there's one specifically in relation to costs, to ensure that costs incurred are reasonable and proportionate. And again, that might be a challenge for some practitioners, as it always is. And of course, one problem is when litigation gets moving, it tends to get a life of its own sometimes, so that being able to control costs in that way becomes very difficult. Those of us, for example, who've had a dispute, a cross-border dispute, where you may have to get documents translated, I've seen the shock and horror that moves across a client's face when you say, well, Japanese translation is very expensive, and you will find that you know, it might be the most expensive part of the out-of-pockets, and the people get quite concerned about it. But so the controlling of costs can become something hard to do, and obviously the court will take into account the circumstances which might impose unusual costs, such as high translation charges or the need for senior and junior counsel in particular cases, etc., etc. Now, I then turn to deal with the pre-litigation phase. So just as in the Commonwealth Bill we saw we had a genuine steps procedure, in Victoria we have a reasonable steps procedure to resolve the dispute by agreement or to clarify and narrow the issues in dispute before civil proceedings are commenced. And again, there's an obligation on parties to try to resolve the dispute by various measures which are listed but are not prescriptive. And I also make the observation that this doesn't really strike us as particularly novel, but what is novel about it is that it does become part of the court process. Now, the Act proceeds on the presumption that each person involved in a civil dispute will bear that person's costs of compliance with the pre-litigation requirements, unless the rules of court otherwise provide. So you're meant to engage in the pre-action process at your own cost. So I suppose the old letter which said, we hereby demand the sum of X dollars on behalf of our client within 7 days, together with our costs of this letter, that sort of thing these days will have a very short sort of life, because that would now be regarded as the old pre-action letter will presumably be subsumed in these requirements. As I mentioned with the Commonwealth, just as there is a costs penalty if you don't comply, again there is under the Victorian model. Now, there's some time's running out, but there are a couple of changes I'd like to refer to specifically because they will change the way we do some things. When you do eventually issue proceedings, you have to certify various things. So we have a certificate that the party has read and understood the overarching obligations at the time of the filing of what they call the first substantive document. The first substantive document will be either an originating motion, writ, complaint, defence, if you're a defendant, reply, counterclaim, third-party notice, but not a summons or interlocutory proceeding. Now, pardon me, the first I suppose rules change which might be of some significance then arises because when you file the first substantive document, you must, or the legal representative must certify that on the factual and legal material available, each allegation of fact has a proper basis, each denial has a proper basis, and there's a proper basis for each non-admission. Now, what does this mean? It sounds fairly bland in a way, but it does have real teeth if what they're going to do is what they've done in Queensland, and that is that you can't plead a simple traverse defence anymore by saying I deny, 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 or not admit, not admit, not admit. You've actually got to take instructions on each allegation to see whether the client knows of the fact which is alleged, And if they say, well, that's not true, I think then you can plead a denial, obviously. If they don't know, then they would plead a non-admission. Now, it might seem that's what we're already supposed to do as a matter of pleading anyway, but it will become legislated. And I came across some Queensland cases which have dealt with that very point, and the Queensland rules have been changed. The case I refer to in the notes, I won't give you the citation, but it's referred to as Cape York Airlines Proprietary Limited, QBE Insurance Australia. The cite's in the footnotes. But what the court there said is that this has made a fundamental change to the rules of pleading. And Justice Daubney notes there that it's no longer possible to plead a bare traverse in the old-fashioned way under the old rules. So that now what you have to do is to go through this process of examining with your client the pleading and get specific instructions as to whether it's true or untrue, etc., etc. Now, the question will be asked, well, what happens if you don't go through a pre-action procedure? Does that mean you stopped? You can't issue a proceeding? The answer is no. You're entitled to issue your proceeding, and the court can't prevent the commencement of a civil proceeding because of a failure to comply with certification, but non-certification may have costs, consequences, or some other procedural consequence. I see we're running a bit tight on time, so that I'll just mention a couple of other matters worth noting. The new Act also lays great stress on case management. And I think, again, with the background of the recent Owen case in the High Court, this, again, won't be seen as being particularly radical, but the court does have a wide range of case management powers, and I think the purpose of having the pre-action requirement is that the court is going to be able to see how far the parties have got trying to resolve their dispute and whether there should be some other way of dealing with it rather than allowing the dispute to go through the normal course of pleadings, discovery, etc., witness statements, the whole bit, a mediation, then finally reaching trial some 18 months, 2 years or more down the track. The court may try to nip that in the bud a bit by making orders which cut through some of those processes. And I think that's where Mr Hull's got some publicity by saying he was going to stop barristers talking at length or various other time-wasting techniques, and got a lot of publicity. Obviously, he was putting political spin on what I think is simply a group of measures which in some ways spells out what the courts are already doing in some jurisdictions and in some lists. I then pass over, and I said at the outset I wouldn't deal with it, but the changes proposed in relation to discovery. Discovery reform seems to come up about every 10 years in my cycle. It's a bit unusual that they have done that because the Australian law reform has a reference on discovery at the moment. One would think that there may be more proposals coming out of that, which will mean it'll be revisited yet again. And then the final part of the paper, my part of the paper deals with the less restrictive summary judgment test. I will say this, that this in a sense is probably one of the more controversial things in the bill or the Act, in that the Supreme Court judges, when they responded to the civil justice inquiry or the Cashman inquiry, recommended against this measure because they thought that it wouldn't really have much effect in disposing of cases earlier by simply tweaking the test. So you have a slightly lesser test than the test in Day and VRC in the General Steel case. And in fact, that's been the experience in England under the new rules there. They tried to do the same thing, and all that happened was that instead of the matter not going off to trial in the ordinary way because you couldn't satisfy the tougher test, it meant that the summary judgment application became a fully fought cause with, matters of fact becoming contested. And so the English judges have adopted a position that if it looks like developing into that sort of contest, they will refer the matter off for trial anyway. So it is just, I suppose, a useless aspect of the reform. If anybody's got any comments or questions, a talking head is not a great prospect at 7:30 in the morning, but I've got away with it. Yes?
One question. You say that there are cost consequences for the individual client. Do you anticipate that personal cost orders will be made?
They will have that power, yes. Whether they'll actually use it, I mean, at the moment there's also a power to award costs against a party who is, if you like, in the old days, maintaining somebody in litigation by supporting somebody else. So you can make cost orders now, but they're not made very often. This may lead to perhaps a more frequent use of cost orders.
And a variation in the cost order depending on whether or not it's paid by on a party-party basis or otherwise, depending on...
Well, yeah, they don't... I imagine that will be, yes, that'll be part of it. We'll probably see some new cost rules as a result of this. So that we'll just need to see how what rule making comes out of it. But I'd imagine they'll be much more flexible. And of course we've got the whole new cost court structure as well. So there's going to be a need to spell out in some detail, I think, just how that's going to work. Yes.
Just briefly, two things. In relation to genuine attempts to resolve a dispute, do you think there might be a temporal link between the dispute, the attempt to resolve and issuing? For instance, the parties had discussions 2 years ago, became clear they can't resolve it, and one decides to issue 2 years later.
That's a very good point. They don't actually deal with that in the legislation in any sense. I suppose the problem about leaving that sort of time to run is that they use words like circumstances and so on. So you'd have to evaluate whether it was reasonable or not to suddenly, without perhaps any further attempt after 2 years, suddenly launch off into issuing a proceeding. But provided, I suppose, you can satisfy the court that you've exhausted everything and that you've got people on the other side who won't talk to you, and they might be a foreign defendant where they're hard to get hold of, so you've done all you can do, and finally the last straw is something's happened or you've discovered some other loss, you just decide you've got to issue. It would just depend on the reasonableness of that, I imagine, yes, in fact.
Is this going to result, do you think, in a uniform civil procedure rules for all three courts, Supreme County magistrates, like in New South Wales?
It might well. I think there's a lot of talk about doing that. At the moment, of course, they've tried to coordinate the rules. The county court rules now are almost identical to the Supreme Court rules, except for matters where the Supreme Court's got extra jurisdiction. And the same with magistrate. I think we're supposed to be having new magistrates' court rules at some stage, but it would be, one would think the time is right now to perhaps bring in a uniform set of rules, with perhaps just a few changes for the lower jurisdictions. But whether we see that, I don't know. We might just get another, well, one hopes it's not too piecemeal, but just looking at what's covered by the Act, it seems to me that there'll be some fairly substantial changes, even if they're not a complete new set. Yes, sir.
Limitation of actions problems. The client comes to you, you've got a 6-year limitation period, and he rocks up 1 week before.
Oh, yeah.
Is there any amelioration of the cost
I
situation?
think you'd probably say, in terms of the Commonwealth one, that was a situation of urgency where you just have to, you've got no alternative but to do it. I think, not sure that is one of the exceptions. I haven't had to go through that laundry list again, but that strikes me as being where you would justification say that's a circumstance of urgency. I think there's one more.
Yeah. The reforms seem to assume the pre-existence of a dispute. Many pieces of litigation are commenced where there is no dispute. For example, the recovery of debts, where a person may admit the debt but just can't pay it, and the plaintiff might want to get a judgment. What do you think a plaintiff should be doing in that case?
Well, I suppose if the plaintiff was prepared to give terms or something like that, you may want to open up a without prejudice negotiation along the lines of, look, I'll give you time to pay, put up a reasonable proposal to me, and you get no response to that, then you probably say, well, away we go, we'll issue. Where it's quite simple, I would think you don't have to engage in lengthy negotiations. It would just be, look, you owe the money, we're going to be reasonable about it. If you're prepared to give us a proposal, if they don't give you a proposal, then you'd say, well, look, the only thing we can do now is issue. Yeah, sorry. Yes?
Does this apply to proceedings before tribunals, for example, VCAT?
No, not that I'm aware of. I think it's purely a court procedures bill at this stage, or act. It's specifically excluded. I'm relying on the brains trust at this table. Kate informs me, no, that VCAT won't be covered. I suppose, again, VCAT's got its own procedures which aim at doing similar sorts of things, a bit like with the family court in the federal court sphere, so that it wasn't felt necessary to deal with that in this Act. Okay, well, thanks for your attention. Like all these new reforms, I'm sure we will find things that will perplex us and try and cope with them. Thank you.